Welcome. Thanks for joining today's session, Unlocking Charitable Gifts Tied Up in Probate, a webinar presented by Probate Cash. I'm Molly Driscoll, and I'll be your host today. Our presenters today are professionals with extensive experience in all aspects of providing cash advances to individuals and organizers awaiting inheritance or bequest payouts. Mark Harris has been working in the specialty finance industry for 25 years and involved in purchasing over $100 million of assets. Most of the purchases, pursuant to various state laws, require court hearings, many of which Mark has either attended or appeared as counsel. As a result, Mark has the advantage of meeting customers, their lawyers, and establishing relationships to find collaborative solutions for the customers. Mark has spoken at numerous conferences and has been active in working to draft model legislation adopted by many states in the country. Born and raised in Tallahassee, Florida, Mark earned his undergraduate degree from Florida State University and law degree from Nova Southeastern University in Fort Lauderdale. Mark is very active in the community and is an officer on an advisory board for a nonprofit organization. Mark, his wife, and two children reside in Parkland, Florida. Today, he's here to speak about the relatively new business of purchasing interest in actively pending inheritance claims. Mark, could you start us off with a quick overview of what Probate Cash does?
Sure thing. Thanks, Molly. I'd like to first welcome the over 50 people in attendance today representing nonprofit organizations throughout the country. By now, many of you have probably attended or even presented a webinar on Zoom. So we try to make this webinar less like a late night infomercial, but it may sound like an infomercial at times, so bear with us. We purposely scheduled these webinars for approximately 15 minutes to minimize the chances of losing everyone's attention and maximizing the chances that you'll actually gain valuable information for your nonprofit. With that said, let me start by saying that I proudly serve on the executive committee of a nonprofit and fully appreciate the balance of the business side, consisting of almost never-ending fundraising and annual budget planning, compared to the very meaningful hands-on face-to-face time making a difference in the community. Of course, nonprofits cannot achieve its missions without the generous support of its donors, whether the gifts are monthly, quarterly, annually, or more specific to today's topic, financial gifts bequeathed in a will to your nonprofit organization. We're going to start by taking a quick minute to explain the probate process, what Probate Cash does, and how we may be another tool for your nonprofit organization. We'll take questions at the end, but feel free to add them to the chat at any time. Yeah, let me take a moment to explain how Probate Cash can benefit nonprofits. When someone dies, that person either does or does not have a will. Regardless, most of the time a probate case must be opened in the courts. For our purposes today, we will assume that there was a will and the decedent in her will bequeath the financial or other gift to your nonprofit organization. Unlike old television shows where there's a public reading of the will and named beneficiaries walk away with money and items left by the decedent, the probate case ensures that creditors of the decedent have an opportunity to file claims against the estate, and other interested parties have an opportunity to challenge the decedent's will for reasons such as fraud, duress, lack of competency. Of course, that process takes time and money, often in legal fees being spent by the estate. Also, the estate usually needs significant time to sell assets such as real property or other assets in order for the estate to obtain money, so to pay the named beneficiaries, including your nonprofit. Yeah, so to be clear, Probate Cash provides upfront money to the nonprofit against a portion of the anticipated charitable gift that was bequeathed to the nonprofit. We begin the process by reviewing the probate case filed in the courts and then quickly determine the amount of money we can advance to the nonprofit, often within 1 to 2 business days. As Karen alluded, from there, Probate Cash takes the risk and waits out the time until the estate's assets are ordered to be distributed by the probate court. If for any reason that there's not enough money in the estate for the nonprofit to repay us, Probate Cash simply will not be repaid that shortfall. So any such shortfall will not affect also the other beneficiaries of the estate. Those other beneficiaries will still receive whatever they were entitled to receive, provided the estate has the money to pay them at the end of probate. Simply put, the fact that your nonprofit agrees to an advance from us will absolutely have no adverse effect on the estate, its beneficiaries, or even the probate lawyer for the estate. In fact, many probate lawyers now refer their anxious heirs of the estate to Probate Cash, where there used to not be any other option other than for them to wait out the many months or years for the probate court process to conclude.
First and foremost, the nonprofit will be charged a fee for the advance.
As an example, if a nonprofit receives $50,000 today, the nonprofit will obviously not receive that portion of the charitable gift at the time the estate closes. When the estate eventually does close, the executor or personal representative of the estate will have to repay our company the advance amount plus the applicable fee out of the charitable gift otherwise due to the nonprofit.
How does the fee structure work?
Sure. So first, I want to reiterate that Probate Cash does not charge an interest rate because these advances are not loans. They're not loans because one, the advances are not secured by any property or other assets. And two, Probate Cash has no recourse against our customer, in this instance, the nonprofit, in the event we're not repaid. So as mentioned earlier, Probate Cash assumes the risk of non-repayment. For example, if it turns out that your nonprofit would never have received a penny from the estate because the estate's assets were significantly less than anticipated, the nonprofit keeps the advance it received, and Probate Cash does not demand repayment or the repayment fee.
What can nonprofits do to determine if an advance is the right way to proceed for them?
Well, as mentioned before, these advances are not ideal in every situation. In fact, I hope not everyone on our webinar will need our services. If your nonprofit's flush with cash reserves and consistently operates without needing additional cash or can obtain emergency cash through traditional methods such as a bank or other institutional funding, I'd recommend that you proceed in that manner. But if your nonprofit is prone to having immediate cash needs and does not have access to traditional funding, we're here as an additional tool in your fundraising toolbox. I think we can agree that a nonprofit looks more attractive to donors and foundation funders when it demonstrates it has cash on hand. And one of those such tools available to nonprofits includes knowing the pending bequests that are tied up in probate can be partially liquidated if needed by your organization. Clearly, if you don't need cash, that's optimal. But if your nonprofit does have an immediate need for money, your organization should know that Probate Cash is an available option.
Can Probate Cash advance money when the inheritance funds are due from a trust that's not in the probate courts?
Bottom line, Probate Cash can offer immediate funding to nonprofits waiting for a charitable gift, whether that gift is tied up in the probate court or being administered by a trust.
Wow. Well, we're already actually at our 15-minute mark. So as promised, the presenters will stay on to answer your questions. If you need to leave now, we'll be sending everyone a link to the recording of the presentation and the questions and answers. If you want to ask a question offline, please contact Mark Harris at 561-476-0018 or email him at mark, that's M-A-R-C, at probatecash.com. Okay, so what if the will gets thrown out? Does the organization have to repay the advance?
Yeah, so if we've given an advance to the organization and subsequently the will is challenged for some reason, I think I alluded to that before, fraud, duress, lack of competency by the decedent, then no, the organization would not have to repay the advance, unless we found out, of course, the organization was part of that fraud, but I think that's highly unlikely.
Also, can you work with county departments?
And I see that in the chat box from Veronica, thank you. I think I may need a little bit more information, but the bottom line is if the county department is entitled to a gift that's tied up in probate, the answer would be yes. So I think, yes, we do work with county departments, but there may be more to that question. Happy to continue that conversation offline. We're on.
Great. Well, I'm just going to double check to make sure we got everyone. Oh, looks like we have I have another question. How do I start a program to get wills from my donors?
So I think that's a question that everybody in nonprofits would like to have answered. I think that's just a part of the natural part of fundraising. I know for my nonprofit, we're fundraising. That conversation is with other potential donors and existing donors. Have you really thought about what kind of gift you're going to make after you pass away? So what can you be? What kind of legacy can you leave behind?
It looks like we got to everyone. Now, of course, if you think of a question later, you can contact Mark directly. Email Mark, and that's MARC at probatecash.com, or call him at 561-476-0018. So thank you again for joining us, and just have a great day.